This is basically a reciprocal disciplinary action brought pursuant to Part 9 of the Texas Rules of Disciplinary Procedure based on the respondents T. Anthony Guajardo's professional misconduct and disbarment in Arizona. It was an agreed order of disbarment. So we'll go ahead and put on our proof after he's given his opening then.
Go ahead.
Just pretty short, Your Honor. The police court, ladies and gentlemen of the board. I have one witness that came all the way from Utah, so I'm going to try to put her on first because she traveled the longest to get here. My position I've laid out very clearly in that I have not committed any ethical conduct that I'm accused of. What happened in short is I had a client who was deprived of his right to parent, and he had not been served. The judge defaulted. There was no service and no jurisdiction for the court to do that. I filed a judicial complaint against Judge Kramer, and as a result, I was then retaliated against by the judge who filed a bar complaint that led to my situation now. We believe that the evidence will show and we will prove that I did not commit any misrepresentation as was accused by Judge Kramer, in that the evidence, which is the transcripts and the video of the hearing wherein I allegedly misrepresented, clearly show that that didn't happen. I was deprived of due process in that the presiding judge, Judge O'Neill, did not allow me to put on the evidence where the video and the transcripts had been tampered with. I was not allowed to have the video and the transcripts presented during the hearing. Judge O'Neill insisted that he and two members of the panel would review the videos and the transcripts in a separate proceeding in secret without my being present or having any input. I believe that that violated due process as a matter of law because I have a right to be present at all proceedings, and that is textbook law under due process. Also, due process was not allowed in that at the last minute, the bar counsel submitted additional charges that had not been pled in the complaint, nor had they been previously disclosed as required under the scheduling order. Over my objection, the judge went ahead and considered these additional charges that were then prejudicial and led to discipline. That is a violation of due process under the Arizona Court of Appeals. That's clearly established law, and I objected, and Judge O'Neill denied my objection and considered those additional charges in violation of due process. And I believe that the evidence will show and we will prove that there were other defects in the, not only in the judgment of disbarment, but in the way that it was obtained. I have now come to light additional factors that we were not aware of at the time of the hearing, and we will present those.
Let me interrupt you there for just a moment. The record that we have, or at least I have before me, indicates that you consented to a disbarment in January of this year. Is that not correct?
Yes, the disbarment was dated January 30th or 31st, and then the judgment of disbarment was February 2nd of this year.
But you consented to it?
I consented to it on the condition, and that was the only condition, that I was not found guilty or adjudicated of any wrongdoing as to any allegations, not in the complaint and not in any additional allegations. In essence, I was resigning from the practice. And now I'm told that because I consented to resigning or disbarment, then now supposedly I'm faced that I admitted and was found guilty of violations when in fact that's not the case.
What is the status of your Arizona disbarment?
I have appealed it now to the Arizona Supreme Court.
When did that occur?
I'm sorry?
When did that occur?
Actually, just yesterday, Your Honor. Did not have time, but I did give a copy of our notice of appeal to the clerk, and that is one of our exhibits. We believe that once it's all said and done, that if any objective person looks at the videos and the transcripts, there's no way that I can add to the transcripts or the video, and any objective person impartially can discern that I did not misrepresent. Basically, what the judge accused me of is that I lied to him when I said that my client had not been served. I had an affidavit from my client that said he had not been served. There was no affidavit of service. And the judge admitted that if there was no service, he had not had jurisdiction to do anything. But yet, the way that the...
Hold on, Mr.
I'm going to object. At this point, I think he's testifying, and this is supposed to be an opening, so
I agree with that.
like to move on.
I'm trying to determine what your position is so we can know how to proceed. Because I'm a little concerned here that you're asking us to go behind the prior consent, and I'm not sure that we have the authority to do that.
Okay, and I
So-
understand that, Your Honor. I'm building a record because the truth is the truth, and it doesn't change with the circumstances, whether I'm here or in the Arizona or anywhere. The truth remains the truth, and the truth was never allowed to be brought out. The judge didn't let me put on the case. He didn't let me put in the evidence that I wanted.
Well, why don't we have Ms. DeBerry proceed with her proof, and then we can see where we are at that point.
All right, thank you.
Thank you. The petition for reciprocal discipline was filed with the Board of Disciplinary Appeals on February the 22nd, 2017, and an order to show cause was issued by the board on February the 22nd as well, requiring the respondent to show cause within 30 days why identical discipline could not be imposed in Texas. The respondent was served by personal service on March the 15th, 2017, with the petition in order to show cause by Amanda, and I'm going to spell this, B-O-A-K-Y-E, a private process server. The original proofs of service was filed with the board on April the 5th, 2017. On December 13th, 2016, a complaint was filed before the presiding disciplinary judge of the Supreme Court of Arizona in the matter styled in the matter of a suspended member of the State Bar of Arizona, T. Anthony Guajardo, bar number 021500. Respondent, PDJ 2016-9126, State Bar Files number 15-1320 and 15-1817. On January 9th, 2017, respondent's answer was filed in the same matter. On January 31st, 2017, a consent to disbarment with exhibits was filed before the presiding disciplinary judge of the Supreme Court of Arizona. In that case, that included State Bar file numbers 15-1320, 15-1817, 15-3235, 16-0623, 16-0674, 16-1057, 16-2407, 16-2417, 16-3279, 16-3378, 16-3820, 16-3827, 16-3896, and 16-4217. On February the 2nd, 2017, a judgment of disbarment was entered stating that respondent T. Anthony Guajardo was disbarred from the state of Arizona and his name was stricken from the roll of lawyers effective immediately. In the consent to disbarment, the respondent acknowledged the consent for disbarment showed that misconduct as set forth in the formal complaints included violations of 3.1, which is filing frivolous pleadings, basically making meritorious claims and contingent, or claims and contingents that were not meritorious. 3.3a, failure to be candid towards the tribunal. 3.4c, fairness to opposing party and counsel. 8.4c, dishonesty, fraud, deceit, misrepresentation. And 8.4d, which we do not have a similar rule in our rules. Also on count 2, 1.2, which dealt with the scope of the representation. 1.3a, which was not exercising diligence in representing the client. 1.4, which was their communication rule. 1.5, talking about an unreasonable fee. Our standard is different. It's an unconscionable fee. 1.6d, returning documents and unearned fees at the end of a representation. and again, 8.4D, which we do not have. In addition, at the time, the respondent had 12 pending grievances at the time that he stipulated to the resignation. At this or the disbarment. At this time, I would offer petitioner's exhibit number 1, which is a certified copy of the complaint filed before the presiding disciplinary judge of the Arizona Supreme Court in the matter of a suspended member of the State Bar of Arizona, T. Anthony Guajardo, bar number 02500. A certified copy of the respondent's answer in the same matter, a certified copy of the consent to disbarment in that matter, and a certified copy of the judgment of disbarment that included all the file numbers of all the cases that were that had formal charges as well as the pending matters. And exhibit number 5 is the original certificate from Blake A. Hawthorne, clerk of the Supreme Court, dated April 3rd, 2017, which indicates that respondent is licensed and authorized to practice law in the state of Texas. May I approach?
Right.
Chairman Kittner, are those admitted?
Have you offered them?
I did.
Any objection?
No objection, Your Honor.
Admitted.
At this time, the commission seeks disbarment as a reciprocal discipline pursuant to Part 9 of the Texas Rules of Disciplinary Procedure.
Mr. Berry, what's the legal standard by which the Board of Disciplinary Appeals reviews reciprocal discipline cases?
The standard?
Yes.
I'm not sure I understand.
Is it mandatory on us? Are there any exceptions? I mean,
I know of no exceptions. There's some defenses. He would have to prove the defense, but you can't go behind the judgment of the judgment in Arizona to look at the underlying facts in the case.
thank you.
What is your position with reference to the finality of this if he has filed an appeal?
It's my understanding that you can't appeal something that you've agreed to. I didn't know about that until this morning, so I haven't had time to research Arizona's position on that.
All right.
Even don't know that at this point whether it matters for our purposes. I don't think it's relevant to these proceedings since we have a judgment from another jurisdiction.
Any other questions?
Yeah.
Mr.
What's your
Guzman?
position on his argument in the answer that there were no findings made? That the proposal to consent to disbarment means there will be no findings made, and if there's no findings, then can we rely upon?
I think this is very similar to what we do with resignations in lieu of discipline. It also goes to his claim that all these other charges were added later. I think the ones that he's referring to, because I've looked at the original petition, and then there was an amended petition where they just changed the numbering of the paragraphs, but everything else was the same. What they did in the final, in his stipulation as well as the order, was they added the pending grievances. When we do a resignation in lieu of, it's the same thing. We'll put everything that we have pending on them, because if they come back for reinstatement later, apply for reinstatement, those are all considered then, so we don't want to lose track of that. And so that's included. It's very similar to what we would do in a resignation in lieu of discipline. We put those in part of our answer, actually. So they've attached it as an exhibit.
This is not a case in which there was a resignation in lieu of discipline. Would the compulsory discipline rules application in Texas be different if in Arizona there had been a resignation in lieu of discipline? Would
Okay.
there be a compulsory process here?
If there was a resignation in lieu of disciplinary,
Yes.
absolutely, yes.
It sounded from what Mr. Guajardo said in his opening that, in effect, he was doing a resignation in lieu of discipline in Arizona. Is that acceptable punishment in the sense of the reciprocal?
It has the same effect as a disbarment.
I understand that, but I'm asking from the disciplinary counsel's position if there was a resignation in lieu of discipline. Would that be acceptable, and could you do that instead of a disbarment?
Today, I mean, in a case where he was,
And as an outcome of this particular matter?
okay, if it had been a resignation in lieu of discipline in Arizona, could we do a resignation in lieu of discipline here?
Correct.
I think we would file a petition with the board seeking reciprocal discipline, but then he could resign in lieu of discipline, yes. It would be possible either before or after we filed a petition.
Any other questions for Mr. Berry? All right, thank you.
Thank you.
Mr. Guajardo, do you have any response?
Yes, Your Honor. Just briefly respond to,
And let me just ask you, because it sounded like to me what you did in Arizona was what we have here is a resignation in lieu of discipline. Is that acceptable for the result of this outcome as far as you're concerned?
it would have been, Your Honor, except I became aware of some very unique circumstances that are extraordinary that go to the heart of what I believe to be, at that time, a fair resolution that I was not aware of. Those circumstances are extraordinary and would be a manifest injustice should this court just rubber stamp the Arizona, because in my opinion, the Constitution is at the heart of the rule of law. And I have stood up for the rule of law for 40 years in Texas. I never had one single complaint in Texas from a client, from a judge, from anyone. And after 40 years as a tenured attorney, all of a sudden in one case with one judge, I had a complaint filed by the judge, and then I'm disbarred. And all these other cases, there was never any findings of fact or conclusions of law. In fact, I responded to each of those cases, including the complaint. And the bulk of those allegations are really not merited because, for example, one of them, I actually won a case for a lady in a divorce case where she got $26,000 in retirement, she got $50,000 in stocks and bonds, she got half of the 401k, which is another substantial amount, and I had a complaint filed against me. I mean, you can't win. So I cannot help that people will file a complaint. But I responded to all these complaints. I have similar cases where there.
Well, let me stop you there because I'm concerned.
But I did not know that Judge O'Neill, for example, this is just one example of one of the things I found out. I didn't know that the judge that I filed a complaint against was the chairman of the Judicial Commission. I filed a complaint against him with the commission that he's the chairman of. And Judge O'Neill is a co-chairman of that same commission. And Judge O'Neill had a conflict of interest because my complaint was discussed with the chairman who had filed the complaint against me. So he did not disclose that he had a conflict because he in fact participated in the adjudication of that judicial complaint. There was also some other things that I was not aware of. In fact, that now I believe that makes the judgment null and void. And I'm prepared to present that evidence in my exhibits. Judge O'Neill was previously a Superior Court judge in Pinal County.
I think we're getting into testimony,
Right.
whatever.
But that's
what
why
I'm trying to find out is what you're asking us to do, because again, as was asked earlier, I think there's a significant question as to what we can do in a reciprocal discipline case. There are defenses, but going behind the record, I don't believe is one of them. And trying to understand what occurred here, because if you consented to the discipline and the disbarment, that sounds like our resignation in lieu of. So I'm just trying to.
That was what I had agreed to, not knowing what I know now about what happened with Judge O'Neill's handling of my case. Judge O'Neill has so many different things that were done.
A second. No question.
Mr. Guajardo, I'm interested in the appeal you filed.
Yes.
What was it? Styled just an appeal, or is it a petition for review? What is the nature of the appeal?
Yes, it's a petition for review, a de novo review. And the Supreme Court can go behind the record because it's a de novo. In other words, they can go behind the consent. And the reason-
Are there any time restrictions on filing it?
Yes, and that deadline went by, but I am able to ask an extension, which I did. And the reason I was able to request an extension is because I was not aware of the extraordinary circumstances that warranted remedying manifest injustice.
In essence, some form of a discovery rule.
Yes, I was not given full disclosure.
Have you provided all of these documents to the clerk for us so that we have them here?
I did not provide the actual petition and review, but I would be able to do that. Petition for review is a very lengthy document, and I simply just filed a copy of my notice of appeal.
And are you going to do that?
I filed it with the court today.
Are you going to supplement the record?
Yes, that's my intent is today, ask that the notice of appeal be admitted and considered.
Next, my question is, are you contending that the matter before us is premature?
Exactly.
Because the Supreme Court has to rule on your motions?
That's correct. And also, I'm also a member of the United States Supreme Court. I handled more than one Supreme Court case. One of them was a Texas case where I was plaintiff's counsel in the undocumented children's case in 1980 that struck down the Texas law that excluded children from public education. I argued along with counsel, Peter Schaaf in California. That was a one-of-a-kind 5-4 decision. Justice Marshall delivered the decision, and it stands up to good law even today. It survived the test of time. That is the kind of attorney that I am, not what Arizona is saying. I have been an assistant United States attorney for 3 years in the Southern District. I was president of the federal bar in San Antonio, and I have never had a complaint in Texas. Not one, not a single one, not from a judge, not from a client, from anybody. And the Arizona experience would want you to believe, if what they're saying is true, that I am not fit to practice law, basically, and that's not the case.
But do you intend to practice law in Arizona again? Because again, there was a consent to the disbarment. I'm
Right.
trying to figure out what your goal here is.
My intent is to not practice law in Arizona because I've retired from Arizona. I'm a Texan and I want to live in Texas. I love Texas. I've been here most of my life. And I want to practice nonprofit law and give back to the community. I've been doing pro bono in Texas for more than I can remember, and at least 200 hours of pro bono are contributed every year by myself. And I want to continue that. I want to give back to the community. The question I ask myself now is, how can I serve? I want to be able to give back to the community because I've been very blessed to be able to have the privilege and honor to practice law in Texas.
Up until your resignation or your consent, were you practicing law in Arizona? Was that your primary residence and place of practice?
Well, actually, I had Texas cases as well. I've had a number of Texas cases here. In fact, I had several successful Title VII cases in employment discrimination, and that is because I was an administrative law judge with EEOC, and I was with the government for 12 years, and I adjudicated those cases. So I've had several Texas cases on an annual basis where I practice law in Texas.
Hold on just a second. Mr. Berry, what is your position if, in fact, he has filed a timely appeal from the consent to discipline? Is this proceeding premature?
I don't believe it is because when it's an agreed judgment,
Well, I understand it's an agreed judgment, but he's appealing it, and
I haven't seen, I mean, he says he has, I haven't seen.
well, I'm assuming he has. He's not gonna, and we've seen the copy of the appeal.
Mr. Guajardo, you have any stay of the effectiveness of the consent disbarment in Phoenix, either currently, or do you have a pending application for a stay of that?
No, Your Honor. What my understanding is that I would not be allowed to practice in Arizona until the case is adjudicated, but it's de novo review. So I'm not asking that I be allowed to practice law in Arizona during dependency, so I don't need a stay because I'm voluntarily not practicing law in Arizona. The reason I think it's important here, I'm sorry, go ahead.
Go ahead.
What, if we agree with you that this is premature, at this time, what do you believe your status would be as far as practicing law in Texas?
It would be the same status. I would not practice until the appeal is adjudicated. And the reason I think that's important is because one of the things that the Rule 9 of the Texas Rules of Reciprocal Discipline is that the heart of the matter in defenses and reciprocal discipline is that there be due process. And the basis of my appeal is that I was not given due process.
And so if we agree that this is premature and you have the right to go forward in Arizona with your appeal, you agree that you can't practice law in Texas during that whole time period?
That's correct, and I don't intend to, although I will continue to come to Texas because I have my family here and I have family in Arizona, but I would not practice law in Texas until the appeal is adjudicated.
If the Arizona court stays with the decision, denies your appeal, would you come back to this board?
Well, I would only to the extent that I would ask.
Come back to this board, do you need this witness?
The only reason I brought this witness is because it backs up my exhibits, and I would move those into evidence at this time, and we can dispense with the witness. But the reason I think that I would come back to this court would be to ask for a stay pending a de novo review by the United States Supreme Court. I am a member of the United States Supreme Court, and the United States Supreme Court has an identical case pending before it at this time by another Arizona attorney, and that would be dispositive of my case. In fact, I can connect you with the attorney that's presenting the case. He gave me permission if the court wants to hear from him by telephone, and he would explain the basis of the brief, or this court can grant me 2 weeks and I can provide all the information as to the United States Supreme Court case and file a copy of the brief in that case. Because the Arizona case ultimately would not be dispositive of the United States Supreme Court case because that's de novo, and I'm a member of that court. I've actually argued several cases there.
So we can move along here. What exhibits would you want to have in
Yes,
let's
Your
see if
Honor.
we can get some agreement on that so we can.
Yes, Your Honor. The exhibits are, the first exhibit is Exhibit 1, which is already tendered with the clerk's office and with provided copies. That exhibit is an official record from the State Bar saying that I was not adjudicated of any findings of fact regarding misconduct. The second exhibit is a pro bono certificate from Frank Stevenson, the president of the State Bar of Texas, and signed by the Chief Justice of the Supreme Court, Nathan Heck. The third one, I believe, is an exhibit as to the lack of validity of the oath of office of Judge O'Neill. He never was sworn. There's state law in Arizona that requires that all justices of the Supreme Court must take a mandatory oath, which was never done, and it has to be filed with the Secretary of State. That was not done. The fourth exhibit is an IRS letter of determination showing that the State Bar of Texas, the State Bar of Arizona is a 501c6, a trade business association, and does not have any prosecutorial powers. They have no authority to enforce anything. And them being a trade association, and that status has never been changed, and they're never asked to be a quasi-governmental body, then anything they did to disbar me is also null and void because they don't have the authority. They never went and obtained prosecutorial powers. I was not aware of any of this. And then I have the exhibit 4, which is 4 or 5, I believe. That exhibit shows a sampling of Judge O'Neill's actual signature. And that actual signature was never signed on my judgment. It was signed by who knows who, but it's not, for a fact, it is not Judge O'Neill's signature. And that would also make the judgment null and void. Those are basically it, except for my notice of appeal, which I wanted to add. The additional fact that came to light as well is that the bar rules are not adopted by Arizona statute as required. They must be adopted as law, and that was never done. Judge O'Neill was appointed.
Hold on a second. Are you offering those?
I'm offering them I'm offering exhibits 1 through 6 at this time, Your Honor.
And I would object to all of them at this time. The first one is an email that's not authenticated. The second one was his pro bono certificate, which I don't think is relevant to the proceedings before this panel at this time. The third one, the lack of oath of office, again, They're not certified copies, they're not authenticated in any way, there's no business record affidavit to that, there's nothing with that. We don't know that there's complete records that are available. Number 4, the IRS letter, again, is not authenticated in any way, and if it's not a state agency, then he's not required to take the oath, so it negates his claim on his 3rd exhibit. And the signatures, I don't think are relevant. The main difference there, again, they're not certified copies. They're not authenticated anyway. There's not a business record affidavit. And the fact that he used an electronic signature 4 years, I mean, those exhibits were from 2011 and 2013. We're now in 2017, where a lot of judges use electronic signatures anyway. So I don't think they're relevant. I think there's some real issue with their admissibility because they're not authenticated.
Any other objections?
I don't think so.
What about your witness? What would she add to this?
She was only going to testify as to the due process issue, so what I'm submitting and proffering is that she would investigated the allegations, and she was present before, during, and after, and she would corroborate my testimony that in fact there was never any evidence of misrepresentation proven. And that's also supported by Judge O'Neill's decision. He says that he reviewed the tapes, 2 tapes and 2 transcripts in private without my being present over my objection, which is already, as we know, textbook law. I have a right to be present at all proceedings and all deliberations where it's critical.
Hold on.
I guess my question is, but there wasn't this proceeding because you chose not to have one.
I'm sorry?
There wasn't a proceeding because you chose not to have one.
I'm talking about the misrepresentation issue. There was a proceeding, but there wasn't a proceeding in the consent to disbarment. But I was not aware of the deficiencies in the other material manifest injustice due process issues. I became aware of those now. And that's the basis of my appeal. Primarily, it's that there were things that should have been disclosed to me that I was not aware of. So it was not an intelligent, knowingly intelligent decision on my part. I wasn't given all the facts that I should have had in order to make an intelligent, knowing decision about whether I should consent.
So what was the time period between when you received the email and when you had made the decision to consent to disbarment?
My email was received January 31, and the judgment of disbarment was February 2nd. There was just a matter of days before.
So when did you decide? At what point did you make the decision personally that this is what you
I made a decision when I became aware that Judge O'Neill had committed nefarious, unconstitutional issues. We've been very much aware of what's going on in the news, where our constitutional democracy is being hacked by the Russians. So my belief is that the Constitution should be sacred, and so if there's a constitutional violation by a judge that was committed knowingly and willingly against me, and I didn't know that was happening, the judge should not be able to be above the law.
And was he so there's 12 allegations.
The 12 allegations I responded to, and they were never proven. In fact, they had months and months to decide, and that never was charged.
Was he involved in all 12 of the allegations?
I believe he was, because Judge O'Neill is the chief financial officer of the state bar. He provides the money and the salaries to the state bar employees, including the prosecutor, in my case, Shauna Miller.
So one of the allegations in the second part of the complaint is that a client said they hired you for immigration work, paid you a fee, but the person wasn't eligible to receive those immigration services. And so how was Judge O'Neill involved in that complaint?
Okay, I'll tell you. The reason that I was found allegedly in violation of the ethical rule of due diligence is because the state bar picked up the phone and called the immigration chief judge's office, and Ms. Barnes supposedly stated that I had not committed sufficient due diligence. And they had come up with this expert witness who is the chief prosecutor for the chief immigration judge, who is biased, and they never asked any of the immigration attorneys who've been practicing. There's many who are experts in immigration law. They used a prosecutor of the chief immigration judge's office who has an interest in finding me guilty. So if they had asked any of the attorneys who practice immigration law, like myself, they would have said that I did complete due diligence. I did, in fact, inquire as to my client's prior history in immigration. I interviewed all of the potential witnesses, and I even called ICE to determine the status. I did everything that any lawyer could have done.
You knew all those facts, but chose not to have an evidentiary hearing to test it?
That's correct. The reason I did that is because it would have cost me $50,000 to $100,000 to fight all those complaints. I did consult with a former Chief Justice of the Arizona Supreme Court, Justice Thomas Slackett, and he said, Mr. Guajardo, these complaints are silly. He says, if I would represent you, it
I'm
would
gonna
cost you at least
object.
$50,000. I don't have that
I'm
kind of
going to
money.
object, this is hearsay at this point.
I didn't have the money to represent myself. I didn't have the money to put on the case. And they were going to essentially put me through the mill for each one of those, one by one by one. And it just, I was bankrupt. I'm basically living on Social Security right now, and I don't have the money.
Mr. Guajardo, over the last 10 years, let's say, how would you break down your time that you spend practicing in Arizona and in Texas percentage-wise?
Okay, I would say about 15% in Texas and 85% in Arizona.
Are
And
you,
that's just a rough estimate.
all right, sir, and are you licensed in any other states other than Texas and
No,
Arizona?
I'm not.
Thank
I
you.
was here for 25 years, continuously, exclusively in Texas.
Okay,
And then
Mr.
for the last
Guajardo.
15, I was mostly in Arizona and some in Texas.
Mr. Guajardo, we need to move on here. Is there anything else you want to offer at this point?
Yes, Your Honor, I would like to proffer, be given time to file a copy of the brief in the United States Supreme Court that would be dispositive of my case with the U.S. Supreme Court. And I'd like to be able at that time brief the issue that was raised of due process in light of my appeal. I believe the court is deserving of all the information and law on that issue. And I was really rushed into this.
Anything else you want to do at this point?
No, Your Honor, if I can get 30 days to do that, two things, to go ahead and get a brief filed, and then also to get an extension on briefing the due process issue that was raised by counsel.
All right. Thank you very much.
Yes, Your Honor.
Mr. Barry, do you have anything in response? Otherwise, we're going to move on.
I don't at this
All
point.
right, thank you very much. We'll take the matter under advisement. We'll get back to you, Mr. Guajardo, on any supplemental filings. Thank you very much.
Thank you, Your Honor.
Can we give him a time deadline?